Good morning. Can I begin by wishing everybody a Happy New Year and welcome to the first meeting of the Education and Culture Committee in 2014. Can I remind everyone present that they should switch off their mobile phones and any other electronic devices as they may affect the broadcasting system. Today we will continue our consideration of Stage 2 of the Children and Young People Scotland Bill, and can I welcome Aileen Campbell, the Minister for Children and Young People, and our accompanying officials to the committee this morning, and Happy New Year, Minister. Officials are of course not permitted to participate in the formal proceedings of the committee. A number of non-committee members will participate in the course of today's proceedings, and I'm sure they will join us shortly. We will not go beyond Part 7 of the bill today, and depending on the progress we make, I will conclude proceedings at a suitable point. Any amendments that we do not reach today will be dealt with at our next meeting on the 14th of January. Can I move straight on, therefore, to the next part of Stage 2? And can I call Amendment 6 in the name of Liz Smith, grouped with other amendments as shown in the groupings. Liz Smith to move Amendment 6 and to speak to all amendments in the group.
Thank you, Convener. And can I move Amendment 6 in my name? Can I also apologise for the lengthy list of amendments within this section, but I know members are very aware of the Conservatives' long-standing concern about this aspect of the bill, both from a substantive and from an organisational and cost perspective. After studying at length the evidence presented to the committee, and on that basis, we want to replace the Scottish Government's policies with those which we believe are more practical and which can command a wider support amongst the public and the professionals on the front line. In the first instance, we would prefer to see the provision of a universal health visitor system of the type proposed and argued for very convincingly by the Royal Colleges of Nursing and of Midwives, which attaches all immediately pre-birth children up to the age of 5 to a qualified and registered health visitor. Secondly, we believe that beyond age 5, on account of the evidence provided, including the unanimous findings of the Finance Committee in this Parliament, that named persons should be targeted at the most vulnerable children, the definition for which is provided by some of the amendments, so as to ensure that what are very clearly limited resources are also targeted on these children, rather than spending them on the vast number of children for whom even the Scottish Government acknowledges there is no compelling need. Thirdly, we strongly believe that it is not practical, nor indeed consistent with many other aspects of Scottish legislation, to include 16 to 18-year-olds in a category of the child. And finally, we believe that there should be some aspects of opt-out, again a principle which I note the Scottish Government has accepted within some of its own amendments. Convener, the amendments in my name in this section seek to alter the named person proposals contained within the bill so as to concentrate help on our most vulnerable children and to redress the balance between the state and parental responsibility, the latter of which we believe is likely to be seriously undermined by the Scottish Government's policy. Amendments 6 to 14, 22 to 40, 42 to 44 and 51 would remove the term young person from the named person sections of the bill, with Amendment 40 designed to define a child as a person who has not attained the age of 16, thereby limiting the scope of the named person's proposals to groups of children under the age of 16. As Professor Kenneth Norrie told this committee, as a child increases in age, they increase in capacity and have an increased right to make their own decisions and to determine how they will lead their own lives. Traditionally, 16 has been the age beyond which Scots law recognises a young person to be free of adult supervision, and there is no reason for this bill to state differently. As things stand, the Scottish Government seeks to place all 17 and 18-year-olds under the supervision of a state-appointed guardian. This is wholly unnecessary, and it was pointed out by Highland Region that it might very well be unworkable. The idea that two 17-year-olds with an infant child will be under the supervision of not one or two, but of 3 named persons, each with a remit to become more involved in their family life, is, I think, quite frankly, ridiculous, and would bring about a situation whereby there would inevitably be a dilution of resources for those most in need. Amendments 15 to 18, 20 and 21, on the same principle, they would limit the named person service to vulnerable children once they reach school age. Designed specifically with the concerns of the Scottish Parent-Teacher Council, the Faculty of Advocates and the Law Society in mind, these amendments would ensure that the wishes of parents are better reflected in legislation and that the system is not swamped with children who do not need to be there. Amendment 17 introduces a definition of a vulnerable child based upon existing legislation, seeking to bring them some additional clarity, but also ensuring that the legislation is better targeted towards those who actually require assistance. Amendments 58 to 63, 65 and 83 introduce safeguards which would enable parents and children to opt out of the named person scheme. Such a provision would better reflect the wishes of parents and guardians across the country, many of whom have voiced considerable concern about the proposals. With regards to the specifics, when a request to opt out is lodged, Amendment 61 makes it clear that due regard would have to be given to the views of the child itself. Moreover, should a parent change their mind or should a child of sufficient maturity request the opt-out to be cancelled, then that option would remain open. Amendment 62 considers the duties placed on what would be the outgoing opted-out service provider. These would include informing other services provides that the child has opted out, which would see their wishes properly reflected. Convener, if I could just sum up by saying that we feel very strongly, as I think the Parliament knows, about this section of the bill, and I would ask the members to consider very carefully the 4 different reasons why we feel that this policy needs to be amended. Thank you.
Thank you very much. Can I ask the Minister to speak to Amendment 133 and other amendments in the group? Minister.
Thank you, Convener. As a result of work undertaken by the Care Inspectorate and the Scottish Government, conditions of registration have been amended to make sure that services within secure accommodation are only provided for young people up to the age of 18 and that this is communicated to providers. Previously, there have been a very limited number of occasions where young people have remained insecure beyond reaching the age of 18 in order to complete training or exams. Amendments 133, 134 and 135 in my name accordingly remove the duty on secure care providers to continue to provide the named person service for children aged 18 or over as it is unnecessary. Amendments 6, 8 to 14, 16, 19, 22 to 44 and 51 seek to remove support for children and their families even where they have identified needs, at the very time when they may be facing the challenges of transition to adult services and post-school services. Many organisations and parents have stressed to us the importance of coordinated support from the school and other professionals as children with complex needs approach 17 and 18 years. The removal of the named person would simply heighten their concerns. We all recognise that young people aged 16 or younger have varying degrees of concern, skill and maturity, and the majority of them will be able to reach their own decisions on the issues affecting them, either independently or with support and help from family, from friends, advisors and other professionals. Where concerns are already known, there should be actions and support put in place, but no one knows what might happen in the next days, weeks or months. Children from all backgrounds at any age may need help and support. They may look to family and friends, but where they turn to public services for help, it makes sense for those approached to be in the best place to offer advice. The combined effect of Amendments 15, 17, 18, 20 and 21 would be to negate the early intervention and preventative role of the named person. The named person provides the framework to intervene early, enabling parents to discuss concerns they have and offering support. This is not done before children might be considered vulnerable, so they do not become vulnerable. Practice teaches us that we cannot always identify which children are vulnerable until crises develop, by which time it may be too late. That is what the named person was designed to prevent from happening. In response to Liz Smith's points that the named person approach might dilute action to support the most vulnerable, evidence shows that that's not happened where the GIRFEC approach is implemented effectively, as the focus on early intervention in the universal services helps ensure that those working with the most vulnerable children have the capacity to do so. So therefore I can't accept amendments suggested by Liz Smith. A fundamental purpose of our bill to turn to the named person opt-out is to encourage early intervention and prevention, working with children and their families to offer support earlier than has been the practice in the past, where thresholds of vulnerability or need have operated. And that's why we wish to establish the named person service in universal services. It is a service that is made available for all children and which will provide them with support and advice. If a child or young person does not wish to engage, they do not need to unless there was a more serious concern about the child which demanded that services become involved. The bill as drafted places the child at the centre while recognising the real importance of parents and the family. The amendments remove the central focus from the child and put the parent at the centre. Parents clearly have a role, but as the child matures, he or she will have the increased ability to take decisions for themselves. The aim of the named person, as currently drafted in the bill, is to provide a seamless service for children and families which can flow easily from the routine support available through day-to-day activity of education staff into an enhanced level of support where required, and then back to the routine where possible. The amendment calls for services to dissect the role in an artificial way. We want greater consistency of support approach through Scotland, but this amendment means services would have to develop a two-tier approach with bureaucratic procedures for opting out and opting back in. The amendments would have a major impact on professionals. Apart from the added bureaucracy and reinforcement of silos that they would generate, there would be significant confusion over practitioners' roles in relation to children who are part of the named person service and, separately, those who have been opted out. All we would have from these amendments is additional bureaucracy, greater confusion amongst practitioners and barriers to early intervention. For those reasons, I can't support amendments 58 to 63, 65 and 83. So in summary, Convener, I support my amendments 133, 134 and 135 in this group and don't support the other amendments within this group. Convener, thank you.
Thank you very much. If other members who wish to speak to any of these amendments would please indicate, but can I begin by calling Liam MacArthur?
Thank you very much, Convener. I think, as Liz Smith indicated, this was probably the area of most note and controversy, certainly in early consideration of stage one. Unlike Liz Smith, I've made clear that I understand and support the principle underlying the provisions of named person, but like a number of witnesses and indeed Liz Smith, I'm concerned at the practical implications in terms of the way in which resources would be allocated and the circumstances under which information would be shared. We'll come to the latter issue in due course, but on the former, I think it's still not clear whether or not the focus on the well-being of a child as opposed to the narrower definition of welfare will have the effect, in some cases, of seeing resources and attention spread too thinly, with the risk that cases of genuine welfare concern are not picked up or not picked up early enough. I think we should also acknowledge the evidence we heard at stage one suggesting that applying the named person provision through the teenage years becomes increasingly problematic. Even Highland Council, an exemplar in many aspects, appears to have been unable to make this aspect of the named person approach work. That being the case, while I would not go as far as Liz Smith wishes to go in some of her amendments, I would question whether insisting on a named person up to the age of 18 is either necessary or achievable. If not, why then run the risk of seeing scarce resources targeted at trying to do what even you, Convener, I think, from your own personal experience, have acknowledged is a formidable task. I think we also need to recognise the fear that some practitioners may be drawn into taking an unnecessarily interventionist approach, possibly with the best of intentions, but which is neither in the interest of the child nor in keeping with the spirit of what we are seeking to achieve through this legislation. It may be difficult to guard against this eventuality entirely, but it is one to which we need to be alive and where the legislation and subsequent guidance need to be as robust as possible. Liz Smith's proposals for leaving open the possibility of opting out are, I think, interesting. On the face of it, this would seem pragmatic and likely to reduce any risk of legal challenge. My concern would be the basis on which such an opt-out was exercised and subsequently reviewed, but I do think the amendments are useful in at least flushing out that debate. In relation to my concerns regarding information sharing, obviously we will turn to those in a later grouping, but for the time being, that's all I have to say. Thank you, Convener.
Thank you. Can I call Neil Bibby?
Thank you. Thank you, Convener. As I've said previously, in principle, I have no objection to the provision for a named person to be put in the bill. I want the best possible protection and support system for our children, like many other members will want as well. But it has to work and it has to be properly resourced. Amendments 6, 8 to 11, 13, 14, 23 to 28, 30 to 40, 42 and 43 in the name of Liz Smith, which seek to address a concern that the named person is not needed for young people over the age of 18, are, I think, worthy of support. I was concerned when Bill Alexander, Director of Health and Social Care with Highland Council, gave evidence to the committee, and he questioned why a named person would be needed for most children who have left school. He said, "I do not understand how my daughter, who's 17 and doing performing arts in Manchester, could have a named person. She will not need or want one." There's no doubt that some young people do require additional support after leaving school, and it's important that we have proportionate ways of supporting those individuals and managing their situations. But the vast majority of young people who leave school will neither need nor want a named person. Therefore, I think that a named person for all young people over the age of 16 is not a necessity. Members will know that Highland Council was the national pathfinder for the implementation of GIRFIC, and I think that we need to listen to people like Bill Alexander when he raises such issues. The Scottish Government may have technical issues with these amendments, but the reality is I think there are technical issues with the bill and this part of the bill, and as it stands I am minded to support those amendments in the name of Liz Smith. However, I'm not minded to support Liz Smith's amendments on the issue of opt-out. As I said earlier, I support the principle of the named person. I think those amendments would potentially undermine the purpose of what the Scottish Government are trying to achieve, but like Liam McCarthy, I think it's useful to debate those issues. And I'm also not convinced at this stage the other amendments by Liz Smith on the targeting of the named person role. However, I would say that Jane Baxter and I have made clear that we have concerns over resource issues regarding the number of health visitors, etc., that are needed to provide existing duties, never mind the new named person role, and we do not believe those resource issues have been addressed properly by the Scottish Government. And although we do not support these amendments by Liz Smith at this stage, I do think the Scottish Government need to do more to address the concerns about resource issues in relation to the provision for the named person.
Thank you. Can I call Joan McAlpine?
Very much, Convener. I understand some of the fears that have been expressed. I think it's important, that we recognise parents' role, and for that reason, I've thought really hard and looked at this issue very carefully. And I've come down in the side of having a named person, because I think some of the debate has been misleading in the sense that words like state guardian have been used, and what convinced me to support this was that it's about information sharing to support vulnerable children. And I think all the cases that we've seen of tragedy where children have died, it's been because information hasn't been shared, and I think that's the crucial role of the named person. And for that reason, amendments 58, 59, 60, 61, 62, 63, 65 and 83 in the name of Liz Smith, I would question, in the politest possible way, the logic of those amendments. If the purpose of named person is to protect vulnerable children, if you opt out, then the very people who would be likely to opt out are those who may do harm to their children. And we all know from reading about some of these tragic cases that it's often observed that the parents were quite manipulative and in many ways quite intelligent in the way they evaded scrutiny from the authorities. And I think that's for that reason I think opting out of the system would be completely wrong.
Thank you. Claire Adamson.
Thank you, Convener. If I could speak to the amendments in relation to the reduction from the named person from 18 to 16 years. I don't agree with these amendments because while I do agree that in some circumstances it will be more difficult and there will be young people of that age range who do not need the services of a named person, we're still in the position that there may well be instances where this is important. A child may still be at school, a young person can still be at school, and I think in that sort of time period, it's very important that they still have access to a single point of contact for whatever services there may be. And I know the example was given by Highlands Council, but the young person involved was in further education. We know that there's good pastoral care and higher education and college situations. But for other young people in that age group, they may well not have access to another point of contact for support. And I think it's very important that the named person continue to the age of 18 on that basis.
Thank you very much. If I could just make one or two comments myself on this. This has been a widely debated part of the bill. I think, like others, we came to this part of the bill with some scepticism to ensure that what was being proposed did in fact deal with some of the questions that both members of the public and members of the committee and some of those who gave evidence to the committee had about it. But I have to say I am satisfied, more than satisfied, by the answers that have been provided and the evidence that has been given to the committee on this issue. I don't think it's helpful to describe a named person as a supervision of a state-appointed guardian. I don't think that's in any way helpful or indeed accurate. On the issue, however, the specific issues of some of the amendments that have been put forward by Liz Smith this morning, on amendments 58, 63, 65 and 83 on the opt-out, I have to say I genuinely believe that this is, would be unhelpful if this was the case. For a number of the issues, areas that have already been mentioned, I think it would increase bureaucracy, it would increase confusion, and I certainly have concerns along the same lines as Joan McAlpine's raised. While there would indeed be many parents who would never access a named person and might decide to opt out on that basis and it would do no harm, I think there is an issue or a question mark over the fact that there may well be individuals who would do harm to their children who would use that option of opting out. And I think there's concern about providing that ability for those who wish to evade the kind of services and support that we are talking about. On the issue of 16 to 18-year-olds, I mean, I did, like others, listen very carefully to the evidence of Bill Alexander. And I think while he clearly has a point about young people in this position and with that age group who do not require these services, we heard over the last 2 years, particularly as part of our inquiry, many young people who came to us and talked about their desire to have the kind of support services and the access to services and the ability to go to somebody and speak to somebody. And that certainly they were above the age of 16 in many cases. Some of them certainly would be at school, some of them would be looked after, some of them were looked after at home. And I think many of these children, or young people I should say, are in a vulnerable position, and the ability to have a single individual who they would know as the named person that they could go to, or others could access that person, who would be very obvious who the named person would be in most cases, I think is something that I would not like to lose from the bill. So for all of those reasons, I don't support the amendments being put forward by Liz Smith today. Can I call Liz Smith to wind up and to tell us whether she wishes to press or withdraw her amendment?
Thank you, Convener. And I fully recognise that the Conservatives have a very different view on this entire policy, particularly from the substantive point of view. But I do think also that there remain far too many doubts about the actual costing of this policy, and I think of all the Finance Committee sessions that I've ever seen in this Parliament, the one on the named person was compelling evidence that on all sides of the political spectrum there was a strong feeling that the resourcing of this policy was totally inadequate, and I would ask the Scottish Government to reflect on that. Secondly, I think I'm grateful to the members who've spoken in support of the amendments which deal with the 16 to 18 age group. I'm very convinced indeed that this is an unworkable aspect of the policy, and that's not just from the substantive point of view. I think the mechanics of this make it extremely difficult. So I do acknowledge that we have a fundamental difference of opinion. We have tried to put forward our views without resorting to any of the rhetoric that I think some of the newspapers have. We have based it on fact, and we've also based it on what I think has been quite a lot of the evidence that's been presented to this committee. I am pressing Amendment 6, Convener.
Thank you very much. The question is that Amendment 6 be agreed to. Are we all agreed? We are not. Therefore, there shall be a division. The question is that... Sorry, excuse me for a moment there. Those who wish to support Amendment 6, please indicate. Okay. Those opposed? The result of the vote on Amendment 6, there were 4 votes in favour and 5 votes against. Therefore, Amendment 6 is not agreed to. Can I call Amendment 177 in the name of Jane Baxter, grouped with Amendment 7? Jane Baxter to move Amendment 177 and speak to both amendments in the group. Jane.
Thanks, Convener. Amendment 177 is to prevent the role of the named person being contracted out. As it is currently written, Section 19 suggests that the named person could be someone or another body to whom the service provider has contracted out work. Amendment number 177 seeks to prevent the service provider from contracting out the role of the named person by deleting most of subparagraph 19(3)(a)(2). However, Where the named person is employed directly by the service provider, we would wish to see that they are either a midwife or a health visitor for the crucial early years of a child's life. We would hope that in this being specified within the bill, we will be able to ensure appropriate resourcing is directed towards the role of the health visitor, so we will be supporting Liz Smith's Amendment 7.
Thank you very much.
I move. Yeah.
Thank you very much. Can I call Liz Smith to speak to Amendment 7 and other amendments in the group?
Thank you, Convener. Amendment 7 explicitly states that the named person for 0 to 5 years should be a qualified and registered health visitor, following on from the midwife. And I'm aware the Scottish Government believes this does not account for the flexibility of the Family Nurse Partnership Scheme, but I'm afraid I'm not entirely persuaded of that debate. I've been much more persuaded by the concerns cited by the Royal College of Nursing and by the Royal College of Midwives, who fear that in some situations health boards might allocate named person roles to professionals who are less than appropriately skilled than health visitors. They feel this would be particularly likely in tough economic times when health boards facing financial difficulties. That would indeed be a highly regrettable situation, and one which I think is contrary to the main principles of the bill. For me, the most powerful policy we could put in place to address many of the concerns about the care of our very youngest children is the provision of a universal GP-attached system of qualified and registered health visitors, something which has been very much at the forefront of the campaigns from the professionals on the front line. Indeed, if the bill achieves nothing else, this policy can bring the greatest degree of positive change, and I hope members will support Amendment 7. I move that amendment, and I also indicate my support for Amendment 177.
Very much. Liam MacArthur.
Convener, I'm supportive of Liz Smith's amendment number 7, which, as she has already said, goes some way to addressing part of the concern raised by the RCN at stage 1. This still leaves the not inconsequential matter of adequate resources being made available. To date, as Liz Smith indicated in relation to the earlier grouping, there's been a failure to provide a satisfactory response to concerns that the financial memorandum is calculated in such a way as to ignore the increased staffing requirements for midwives and simply inflates the hours of those already in the sector. But I hope the Minister may be able to accept this amendment at this stage. As Jane Baxter indicated, Amendment 177 is an attempt to prevent the named person role being contracted out wholesale, ensuring it's delivered by appropriately trained staff. This does seem to be a sensible measure and worthy of support, and I'll certainly be supporting it. Thank you.
Thank you very much. Can I call the Minister?
Convener. With respect to Amendment 177, the named person service will be provided by the Health Board for children under school age and the local authority for children of school age. However, some flexibility is required to allow for situations where, for the most appropriate named person is employed by another body. For example, in Highland, they have a lead commissioning model whereby the council provide children's services and employ health visitors. Section 19.3a2 allows health visitors to be appointed as named persons in this situation, notwithstanding that they are not direct employees of the Health Board. We agree that it is very important that a child's named person is properly equipped to carry out their role, and that's why we included Section 19.3b in the bill. This provides that ministers can, by order, specify what training and qualifications the named person must have. This will ensure that staff carrying out the role have the appropriate skills and experience. The safeguard of having the order-making powers in relation to the training, qualifications, experience or position of a named person will provide for a specific description of who can perform the functions and ensure that this service is not contracted out or commissioned from inappropriate organisations. So for those reasons, I don't support Amendment 177. Amendment 7 would restrict the named person for preschool age children to be registered nurses who are health visitors or registered midwives. Now, I'm well aware of the well-intentioned petitioning in this regard. However, leaving no flexibility would not be in the best interests of the child. I agree that in the vast majority of situations, these would be the professionals best placed to fulfil this role. However, the amendment leaves no flexibility for health boards to agree the appointment of another professional in exceptional circumstances, even where this would be in the best interests of the child. The recent development of the Family Nurse Partnership Programme over the last few years with family nurses from a wide variety of nursing backgrounds is a clear example of where having a statutory requirement for the named person to be a midwife or health visitor would not be in the best interests of the child or family. A growing number of vulnerable families have a family nurse providing intensive support while the child is under 2 years. During this time, they are better placed to carry out the named person function for the child, having the skills, the experience, the frequent contact and established relationship with that family. Also, in exceptional circumstances, Convener, it may be that the GP might be the one who undertakes the role of the named person. This is why the bill, as currently drafted, provides that flexibility to allow this to happen. Amendment 177 would prevent that from happening at all. In line with proposed Amendment 177, our statutory guidance will be recommended that for the vast majority of children and families, the named person role for the newborn will be the midwife and then a health visitor. We also have the capacity under Section 19 of the bill to make an order in regard of the training, qualifications and experience of those who can fulfil the named person function. So as a result, I don't support Amendment 7.
Thank you very much. Can I call Jane Baxter to wind up and to tell us whether she wishes to press or withdraw her amendment?
Thank you, Convener. I think that midwives and health visitors play a central role in family life and want to ensure that that's resourced and delivered by appropriately qualified staff. And I think the principle needs to be enshrined in this bill, and I'm not prepared to see that diluted or subject to flexibility. So I'm going to move my amendment, Convener, as it stands.
Okay, thank you. The question is that Amendment 177 be agreed to. Are we all agreed? We are not all agreed, therefore there will be division. Because those members who wish to support Amendment 177, please show. Thank you. Those opposed? The result of the vote on Amendment 177, there were 4 votes in favour and 5 votes against. Therefore, Amendment 177 is not agreed to. Can I call Amendment 7 in the name of Liz Smith, already debated with Amendment 177? Liz Smith, to move or not move?
Moved.
The question is that Amendment 7 be agreed to. Are we all agreed? We are not all agreed. There will be a division. Could those members who wish to support Amendment 7 please show? Thank you. Those against? The result of the vote on Amendment 7, 4 votes in favour, 5 votes against. The amendment is therefore not agreed to. Can I call Amendment 8 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Thank you. Can I call Amendment 129 in the name of the Minister, grouped with Amendments 130, 152 and 156? Minister, to move Amendment 129 and speak to all amendments in the group. Minister.
Thank you, Convener. I move Amendment 129. Amendments 129, 130, 152 and 156 amend the named person provision so that the named person functions will not apply whilst the young person is subject to service law as a member of any of the reserve forces. The local authority will continue to provide the named person function at all times for those young people. This means that while the young person is at home and going about their life in a usual way, the named person service will be available to them. It will only cease to be available during the time they are away with the reserve forces. It would be logistically problematic for the local authority to provide the named person service to a young person when their duties with the armed forces are taking place on MOD premises or out with the local authority area. If the young person is on call, duty or training with the reserve forces, then the MOD will have a duty of care towards that young person. So we do not consider that this will diminish the level of support for the well-being which the young person will receive, as we expect the armed forces to exercise a comparable level of support for well-being while the young person was on duty with them. We intend to negotiate a memorandum of understanding with the MOD to detail how this support for well-being will be maintained. Therefore, Convener, urge the committee to support amendments 129, 130, 152 and 156.
Okay. No other member has indicated they wish to speak. You don't have to wind up, Minister, do you? Thank you. The question is that Amendment 129 be agreed to. Are we all agreed? We are agreed. Can I call Amendment 178 in the name of Jane Baxter, grouped with Amendment 329? Jane Baxter, to move Amendment 178 and speak to both amendments in the group.
Thank you, Convener. This amendment would ensure that the functions of the named person service expressly include preventing harm to the child or young person. This section of the Children and Young People's Bill outlines the functions of the named person service, and this amendment would expressly add preventing harm to the child or young person to the functions of the named person. I believe that the named person can potentially play an important role in preventing harm to the child or young person. Amendment number 178 will further emphasise the importance to the named person in exercising their functions of preventing harm to the child or young person. I move.
Thank you. Can I call Liam MacArthur to speak to Amendment 329 and other amendments in the group?
Thank you very much, Convener. My amendment reflects the concerns highlighted by the Wave Trust and other experts involved in the development of the Keeping the Baby in the Bathwater report. Like Jane Baxter's amendment, Amendment 329 underscores the not unreasonable belief for this bill to have within it a proper emphasis on the need for prevention. I'm bound to say it is disappointing that to date the Minister has seen fit to accept not a single amendment from any opposition member, despite the willingness of all of us to share with her and her officials the areas of concern we have in relation to a bill that nevertheless enjoys cross-party support. Indeed, the sole exception to the Scottish Government's apparently exclusive right to amend this bill was Joan McAlpine's amendment on the theme of preventative action passed at our previous session. So perhaps I could encourage Aileen Campbell to turn over a new leaf in the new year and start showing some evidence of commitment to the collaborative working that we've talked about throughout stage one. Thank you.
Colin Beattie.
Convener, I'm struggling a bit with both of these amendments to see actually what they actually add to the bill. In the case of Amendment 178, the actual functions of the named person are already included. They already include promoting, supporting and safeguarding well-being. In the case of Amendment 329, corporate parents through the bill already have to be alert to matters which might adversely affect the well-being of the child. I don't think that what's being proposed here really adds to that. The concept of well-being was strongly supported in the bill consultation itself and is a widely understood term among the professionals. And, adding these two amendments in doesn't seem to strengthen the bill and doesn't seem to add any level of protection to the child. I would be interested if the Minister can give any indication as to whether guidance might add to that or strengthen this even further. But as it stands at the moment, I just don't see what this is adding.
Okay, thank you very much. Can I call the Minister?
Thank you, Convener. With respect to Amendment 178, I wholeheartedly agree that preventing harm to a child is a crucial objective for all services and indeed the wider community. Public services have responsibilities to look out for and to protect children from harm, from abuse, from exploitation, from trafficking, from neglect. That includes taking action where harm is discovered. But it also means taking preventative action when well-being might be compromised. That is a key aim of this bill and is central to the functions of the named person. We are deliberately promoting the concept of well-being to encourage early intervention and prevention to avoid children ending up in harm, however described. The definition as proposed at section 74 includes key references such as safe, nurtured and healthy, all of which embrace the necessary elements of ensuring preventing harm. This bill seeks to shift culture and practice to ensure that practitioners initiate action to support well-being and not just through the lens of harm or child protection. And that's what promoting, supporting and safeguarding mean. The bill focuses on positive outcomes for children and young people. Preventing harm is a feature of a deficit approach which does not sit with the aims of the bill and could impact adversely on the way practitioners engage with families and with children. And I believe that the bill already embraces the aim of the amendment and is therefore not necessary at this stage. For these reasons, while agreeing with the aim, absolutely agreeing with the aim, I oppose Amendment 178. And turning to Liam MacArthur's amendments and in the spirit in which he raised them, where we feel the bill could be improved, we have worked with stakeholders to draft our own amendments. If we felt an opposition amendment would improve the bill, then we would absolutely support it. And I hope that regardless of whether or not we have supported the opposition amendments, we can still continue to work together to ensure that the guidance and that the subsequent legislation can do what we all want to achieve within this bill, is to make lives better for all children across Scotland. Turning to the specifics, though, around Amendment 329, which Liam MacArthur raised, a key responsibility of corporate parents, as set out in Section 52A of the bill, is being alert to matters which might adversely affect the well-being of children and young people. Well-being is a widely understood definition and quite clearly includes safety from harm. As safe is within the Shinari framework. This committee debated the term well-being at its last Stage 2 session on the bill, and the majority of the committee felt it is a useful holistic term. Consequently, there is no need to specify prevention of harm as a specific duty, as that is what already encapsulated in the existing duty in Section 52A. We can, of course, elaborate on this further in guidance issued to corporate parents under Section 57 of the Bill relating to the exercise of their corporate parenting responsibilities. So therefore, unfortunately for Liam MacArthur, I cannot support his amendment.
Thank you very much. Jane Baxter to wind up and to press or withdraw her amendment.
Thank you, Convener. I welcome much of the Minister's comments, many of the Minister's comments, and fully understand the concept of well-being, but I'm thinking back to comments that Joe McAlpine made earlier on in the session about some of the very distressing cases that have come to light, and so I think there's nothing wrong in having a focus on preventing harm and looking at things through that prism. So I'm going to continue to press the amendment.
Thank you. The question is that Amendment 178 be agreed to. Are we all agreed? We are not. Therefore, there's a division. Would those members who wish to support Amendment 178 please indicate? Thank you. Those opposed? The result of the vote on Amendment 178, 4 votes in favour, 5 against. The amendment is therefore not agreed to. Can I call Amendment 9 in the name of Liz Smith, already debated with Amendment 6? Liz Smith to move or not move?
Not moved.
Thank you. Can I call Amendment 10 in the name of Liz Smith, already debated with Amendment 6? Liz Smith to move or not move?
Not moved.
Thank you. Can I call Amendment 11 in the name of Liz Smith, already debated with Amendment 6? Liz Smith to move or not move?
Not moved.
Call Amendment 12 in the name of Liz Smith, already debated with Amendment 6. Liz Smith to move or not move?
Not moved.
Can I call Amendment 238 in the name of Jane Baxter, already debated with Amendment 216 on day 1? Jane Baxter to move or not move?
Move, Convener.
The question is that Amendment 238 be agreed to. Are we all agreed? Yes. We're not all agreed, therefore there will be division. With those members who wish to support Amendment 238, please show. Thank you. Those against? The result of Amendment 238, the vote on 238, total votes in favour 2, against 7. The amendment is therefore not agreed to. Can I call Amendment 13 in the name of Liz Smith, already debated with Amendment 6? Liz Smith to move or not move?
Not moved.
Thank you. Can I call Amendment 14 in the name of Liz Smith, already debated with Amendment 6? Liz Smith to move or not move?
Not moved.
Can I call Amendment 130 in the name of the Minister, already debated with Amendment 129? Minister to move formally. The question is that Amendment 130 be agreed to. Are we all agreed? We are all agreed. Thank you. The question is that Section 19 be agreed to. Are we all agreed? Thank you. The question is that Section 20 be agreed to. Are we all agreed? We are. Can I call Amendment 15 in the name of Liz Smith, already debated with Amendment 6? Liz Smith to move or not move?
Moved.
The question is that Amendment 15 be agreed to. Are we all agreed? We're not all agreed. Therefore, there will be a division. Can those who wish to support Amendment 15 please show? Okay. Those against? Thank you. The result of the vote on Amendment 15, 1 vote in favour, 8 votes against. The amendment is therefore not agreed to. Can I call Amendment 58 in the name of Liz Smith, already debated with Amendment 6? Liz Smith to move or not move?
Moved.
The question is that Amendment 58 be agreed to. Are we all agreed? We are not all agreed, therefore there will be a division. Can those who wish to support Amendment 58 please show? Those against? The result of the vote on Amendment 58, 1 vote in favour, 8 votes against. The amendment is therefore not agreed to. Can I call Amendment 16 in the name of Liz Smith, already debated with Amendment 6? Liz Smith to move or not move?
Moved.
The question is that Amendment 16 be agreed to. Are we all agreed? We are not all agreed, therefore there is a division. Those members who wish to support Amendment 16, please show. Thank you. Those against? Thank you. The result of the vote on Amendment 16, 1 vote in favour, 8 votes against. The amendment is therefore not agreed to. Can I call Amendment 17 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Not moved. Can I call Amendment 18 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Can I call Amendment 131 in the name of the Minister, grouped with other amendments as shown in the groupings? Minister, to move Amendment 131 and speak to all amendments in the group. Minister.
Convener, I move Amendment 131. These amendments place a duty on Scottish ministers in practice the Scottish Prison Service to provide named person to children 16 to 18 in prison. It is more appropriate and in keeping with the role of the named person that is carried out by someone working closely with them whilst in custody. In practice, this will be the Governor, Deputy Governor or a member of senior management. Prison officers will have a similar role to a pastoral care teacher in this context. The Scottish Prison Service are keen to carry out this role in respect of children aged 16 to 18 in custody, as they consider it will enhance their opportunities to support them during the critical period when they are in custody. Stakeholders have identified leaving prison and moving back into the community as a time which requires better joined-up working and support for young people. This provision of named person service within the prison will support that process. So therefore, I ask you to support amendments 131, 132, 138, 149, 150, 151, 53, 54, 55, 57 and 158. With respect to Amendment 179, as the bill stands, all children from birth up to 18 or school leaving age, whatever is later, will have access to a named person. The local authority will have to make the named person service available for all school children who reside in their area, with only limited exceptions. For example, where the child attends a school in another area or attends an independent school and the duties transfer to other bodies. Children who do not have a standard pattern of school attendance and those who are temporarily or permanently excluded from school will continue to benefit from the named person service. Therefore, we believe this amendment is unnecessary. Statutory guidance will detail the practical arrangements that are to be made for different groups of children. For that reason, I ask the members not to move Amendment 179.
Thank you very much, Minister. Can I call Jane Baxter to speak to Amendment 179 and other amendments in the group?
Thanks, Convener. In lodging Amendment 179, I am seeking clarification of what support is available to children who have been expelled or excluded from school. As we have made clear throughout, while we support the named person in principle, we need assurances that the system is adequately resourced and appropriately supported, and that no child will fall through potential gaps in this system. I move.
I have to move at this stage.
Right, okay.
Thank you very much. Can I call Joan McAlpine?
Yes, I just wanted to talk specifically about Jane Baxter's amendment. As the Minister says, I can't see how it's necessary when we know that the central purpose of the legislation is for all children to have access to a named person, including those who are temporarily or permanently out of full-time education. So I'm quite relaxed and feel that the guidance will outline details of the named person for children who are outside mainstream education, and I'm satisfied with that.
Okay, thank you. Can I call the Minister?
Thank you, Convener. Just on the specific of Amendment 179 and echoing what Joan McAlpine has just said, this is unnecessary as the bill currently places a duty on local authorities to make available the named person service to all children and young people living in their area. This means that even when a child or young person is temporarily or permanently excluded from school, they will be covered by the named person provisions. Therefore, we don't believe that 179 is required, because we already believe it's covered within the bill. So again, I would ask Jane Baxter not to move it.
The question is that Amendment 131 be agreed to. Are we all agreed? Been agreed. Can I call Amendment 19 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Moved.
Thank you. The question is that Amendment 19 be agreed to. Are we all agreed? We're not all agreed, therefore there will be a division. Can those members who wish to support Amendment 19 please indicate? Thank you. Those opposed? Thank you. The result of the vote on Amendment 19, 1 vote in favour, 8 votes against. The amendment is therefore not agreed to. Can I call Amendment 20 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Moved.
The question is that Amendment 20 be agreed to. Are we all agreed? We are not. Therefore, there will be a division. Those members who wish to support Amendment 20, please show. Thank you. Those against? Thank you. The result of the vote on Amendment 20, 1 vote in favour, 8 votes against. The amendment is therefore not agreed to. Can I call Amendment 59 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Thank you. Can I call Amendment 21 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Moved.
The question is that Amendment 21 be agreed to. Are we all agreed? We are not. Therefore, there is a division. Can those members who wish to support Amendment 21 please show? Thank you. Those against? Thank you. The result of the vote on Amendment 21, there was 1 vote in favour, 8 votes against. The amendment is therefore not agreed to. Can I call Amendment 60 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Not moved. Can I call Amendment 132 in the name of the Minister, already debated with Amendment 131? Minister, to move formally.
Moved.
The question is that Amendment 132 be agreed to. Are we all agreed? We are. Can I call Amendment 179 in the name of Jane Baxter, already debated with Amendment 131? Jane Baxter, to move or not move?
Move.
The question is that Amendment 179 be agreed to. Are we all agreed? We are not all agreed. Therefore, there is a division. Those members who wish to support Amendment 179, please show. Those against? Thank you. The result of the vote on Amendment 179, there were 3 votes in favour, 6 votes against. The amendment is therefore not agreed to. The question is that Section 21 be agreed to. Are we all agreed? Yes. Can I call Amendments 133, 134 and 135, all in the name of the Minister and all previously debated? And can I invite the Minister to move Amendments 133 to 135 en bloc?
Moved en bloc.
Thank you. Can I ask whether any member objects to a single question being put on Amendments 133 to 135? No members objected. Therefore, the question is that Amendments 133 to 135 are agreed to. Are we all agreed? We are agreed. Can I call Amendment 22 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Moved.
The question is that Amendment 22 be agreed to. Are we all agreed? We're not all agreed. Therefore, there will be a division. Can I ask members who wish to support Amendment 22 to please indicate? Thank you. Those opposed to Amendment 22? The result of the vote on Amendment 22, there was 1 vote in favour and 8 votes against. The amendment is therefore not agreed to. Can I call Amendment 61 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Not moved. Thank you. Can I call Amendment 23 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Not moved. Can I call Amendment 24 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Can I call Amendment 25 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Call Amendment 26 in the name of Liz Smith, already debated with Amendment 6. Liz Smith, to move or not move?
Not moved.
Call Amendment 27 in the name of Liz Smith, already debated with Amendment 6. Liz Smith, to move or not move?
Not moved.
Can I call Amendment 136 in the name of the Minister, grouped with other amendments as shown in the groupings? Can I invite the Minister to move Amendment 136 and speak to all amendments in the group? Minister.
Thank you. I move Amendment 136. We have listened to stakeholders' concerns throughout Stage 1 and others. After careful consideration of the issue, I propose amendments in my name to tighten up and clarify that information should be shared when it's likely to be relevant to a child's well-being rather than the current might be relevant. These amendments further elaborate on and give context to what was always meant to be a subjective professional decision. They ensure that, where appropriate, the views of the child will be taken into account. The amendments ensure that the holder of the information must take account of any adverse effect on the child's well-being if information is shared, and balance this against the benefit to the child in sharing. If the adverse effect outweighs the benefit, then they must not share. This should help allay concerns held by some that the duties in this section were to be complied with in the absence of any consideration of the child's view or how the child would be affected by the provision of information. Amendment 142 will provide comfort to those professionals who are bound by duties of confidentiality and, as we are aware, can at times find themselves in a dilemma between what should be shared in a child's best interest and the codes binding their profession. Duties of confidentiality may be overridden, but only where the tests in Section 23 and 26 are met. At times, difficult decisions need to be made by professionals, but these provisions, as amended, will ensure that all contributing factors are taken into account. We have listened to the concerns about Section 27. We understand that, as drafted, Section 27 could potentially allow court orders to be breached. As a result, the suggested amendments to Sections 23, 26, 27 and 38 tighten the provisions to ensure this should not happen. Section 27 provides reassurances for professionals in respect only of breaches of duties of confidentiality if they apply the test under Section 26 and comply with the Data Protection Act. These amended provisions should ensure that appropriate information is identified and consideration given to sharing. They achieve improved but not excessive information sharing, which has been the aim of our policy all along. With these proposed amendments, the test for sharing information and the factors to be taken into account in doing so will be more explicit. We will continue to liaise closely with stakeholders and listen to their views, in particular the ICO. As he suggests, we will work in partnership with him in producing clear guidance which will further enhance the application of these provisions in practice. Now, I hope the changes to the bill will be welcomed and accepted. I know that the Law Society and the Information Commissioner's Office has already written to the committee to give broad support to my amendments. Where the Law Society and the Information Commissioner have some remaining concerns about the amendments, I want to offer a reassurance to the committee that our amended provisions only permit the sharing of information in breach of a duty of confidentiality in the circumstances where Sections 23 and 26 are complied with and where, in the interest of the child's well-being, it is necessary to do so. They do not permit or require the breach of any other restrictions on information sharing, including the Data Protection Act. The effect of Amendments 180 and 181 would be to remove Sections 26 and 27 in their entirety, which would be the duties on information holders to share relevant and appropriate information with the named person in a structured and targeted way. These amendments would hinder the ability of the named person service to promote early intervention and engage in preventative work, as there would be less clarity on when and with whom information should be shared, as well as on the criteria to be applied when considering whether to share information. Removal of these sections would remove a major policy aim of the bill. The information sharing provisions in the bill do not alter the application of the existing framework for information sharing under the Data Protection Act. They do not constitute an interference with the ECHR. Moreover, in written evidence, the Information Commissioner's Office said that there are advantages arising from the named person as a single point of contact, particularly in ensuring the consistency and accuracy of information being shared about the child or young person. The Commissioner said Section 26 of the bill also assists with compliance with Principle 1 of the DP Act by providing a lawful basis for the sharing of information by service providers and relevant authorities. So, as for Section 27, practitioners have told us they feel exposed when sharing information, at times finding it difficult to balance doing the right thing with breaching their duty of confidentiality. This section allows practitioners to act in the best interests of the child in the full knowledge that they are protected by law when they are doing the right thing. So therefore, in summary, I ask you to support the amendments in my name and to the member not to move amendments 180 and 181, which are, I believe, unnecessary.
Thank you. Can I call Liz Smith to speak to Amendment 180 and other amendments in the group?
Thank you, Convener. I think from day one, the information sharing issue has been hugely complex and controversial. I think it was generally agreed at the start that Sections 26 and 27 didn't help the safe passage of the bill. It has been the Conservatives' view that these two sections are not necessary, as the Data Protection Act 1998 already covers the requirements for information sharing. Moreover, even with the proposed changes from might be relevant as a phrase to likely to be relevant, there is still confusion about the provisions and how this will be interpreted by the courts. Fundamentally, these sections don't provide the same protection for the personal data as the Data Protection Act. There is therefore the implication that the Act disapplies or that this new measure takes precedence, something that would be incompetent. The DPA already complies with Directive 95/46 EC of the European Parliament and of the Council of October 1995. These sections contain no similar protections. We are very strongly of the view that these provisions should be taken out altogether so as to clarify matters of law and to avoid the risk of later challenge. I will press Amendment 180.
Thank you. Can I call Liam MacArthur?
Convener, as I said earlier, as well as the concerns about the resource implications and a potential for focus on genuine issues of welfare to be diluted, my other anxiety about the practical consequences of the named person proposals arises in the area of information sharing, in particular the safeguards around what information would be shared, when, with whom and under what circumstances. I think Liz Smith has highlighted some of the serious concerns that we heard at stage 1 in relation to sections 26 and 27. I note, however, the Minister's amendments, particularly 137, 141 and 142, which I think do go some way to addressing the concerns I was expressing at stage 1. Nevertheless, the Law Society has raised concerns about Amendment 142 and the potential for it to allow Data Protection Act provisions to be disregarded, while Clan Child Law draws attention to the possibility of confidential information being shared without express consent. This was something that I was raising throughout stage 1, and I would welcome the Minister's response, not just to the Law Society, which I think she's already done, but also to the concerns raised by Clan Child Law, as I'd hoped that where we were going to get to by the end of stage 2 is that a situation where making the consent of the child or young person a requirement in all but the exceptional circumstances was our objective. I'm still hopeful that we can obviate the need to adopt the nuclear option, initially advanced by Professor Norrie, latterly advanced by Liz Smith, but it may well be that we need to return to this at stage 3, or certainly through guidance, in order to finally allay those concerns. Thank you.
Thank you. Can I call George Adam?
Thank you, Convener. I think the information sharing part of this bill is one of the most important parts, because as our colleague Joan McAlpine already mentioned, many of the tragic cases that we've heard about over the years has been, some of the problems have been created by the lack of being able to share information back and forward. But I don't therefore believe that everyone's information should just shared willy-nilly with absolutely everyone in any scenario. But I do believe that the government's amendments have actually tightened this up, made things a lot better, made Liz Smith's Amendment 180 and 181 unnecessary. As the Minister already said, the Law Society have broadly welcomed the amendments, as have the Information Commissioner's Office. So I think these are things that when we look at here, the information part is one of the most important parts of this bill, and I think we have to make sure that this is put forward in such a way that it can make a difference in young people's lives.
Thank you. Just a few comments before I bring the Minister back in. This certainly has been one of the areas we've spent a lot of time looking at and discussing. I think many of the members of the committee had concerns at the start when we received some of the evidence on sections 26 and 27. I think, to be fair though, I think the Minister has answered those questions very well. I think a lot of the concerns were around the language that was used. A lot of that has been tightened up now, and I think I'm certainly very much in favour of the amendments being put forward now by the Government. I think they answer the questions and the concerns that this committee had, and so I very much support those amendments, and therefore feel that the amendments being put forward by Liz Smith today are no longer necessary. Can I call the Minister to wind up?
Convener, and I thank all the members for their comments. My amendments are based on feedback from a wide range of stakeholders, including the Law Society, the Information Commissioner's Office and others. They tighten and clarify the information sharing provisions, as also raised by George Adam. I understand also that the NSPCC wrote to the committee to say they were pleased that the Scottish Government has listened and acted upon the concerns raised about the information sharing provisions. And I will continue to work with any other stakeholders who may have remaining concerns. I think Elizabeth Smith had said in her remarks that there were some stakeholders that remain concerned, and certainly would open that door to them if they want to further engage as the bill progresses to try and allay some of those fears. In response to Liam MacArthur, we want to ensure that the child's views are taken into account when the professional decides whether to share information. They ensure that the amendments ensure that the well-being of the child is balanced with any adverse effect to the child, and they also ensure that confidentiality may only be breached when the stricter tests apply. My amendment should alleviate any concerns raised during the stage 1 evidence. But of course we all want to get to a position where no child is neglected or harmed and where their full potential is reached. That goal can only be achieved through acting early and preventing problems from escalating. The named person needs the information that others hold about a child's well-being to be shared with them, so that these early signs can be picked up on and acted on before a crisis is reached. Therefore, Convener, I ask the committee to support the amendments in my name and to oppose amendments 180 and 181.
Okay, thank you very much. The question is that Amendment 136 be agreed to. Are we all agreed? We are not all agreed there will be a division. Therefore, can I ask those members who support Amendment 136 to please show? Thank you. Those against? The result of the vote on Amendment 136, there were 8 votes in favour and 1 vote against. The amendment is therefore agreed to. Can I call Amendment 28 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Thank you. Can I call Amendment 137 in the name of the Minister, already debated with Amendment 136? Minister, to move formally?
Moved.
The question is that Amendment 137 be agreed to. Are we all agreed? We are not all agreed. Therefore, there will be a division. Can those members who wish to support Amendment 137 please show? Thank you. Those against? The result of the vote on Amendment 137, 8 votes in favour, 1 vote against. The amendment is therefore agreed to. Can I call Amendment 62 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Moved.
The question is that Amendment 62 be agreed to. Are we all agreed? We are not. Therefore, there is a division. Those members who wish to support Amendment 62, please show. Thank you. Those against? The result of the vote on Amendment 62, there was 1 vote in favour, 8 votes against. The amendment is therefore not agreed to. The question is that Section 23 be agreed to. Are we all agreed? We are. Can I call Amendment 138 in the name of the Minister, already debated with Amendment 131? Minister, to move formally.
Moved.
The question is that Amendment 138 be agreed to. Are we all agreed? We are agreed. Can I call Amendment 63 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Not moved. Can I call Amendment 29 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Not moved. Can I call Amendment 30 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Not moved. Can I call Amendment 31 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
The question is that Section 24 be agreed to. Are we all agreed? We are agreed. Can I call Amendment 32 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Not moved. Can I call Amendment 33 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
The question is that Section 25 be agreed to. Are we all agreed? Can I call Amendment 34 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Can I call Amendment 139 in the name of the Minister, already debated with Amendment 136? Minister, to move formally.
Moved.
The question is that Amendment 139 be agreed to. Are we all agreed? We are not all agreed, therefore there is division. With those who wish to support Amendment 139, please show. Thank you. Those opposed? The result of the vote on Amendment 139, 8 votes in favour, 1 vote against. The amendment is therefore agreed to. Can I call Amendment 35 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Not moved. Can I call Amendment 36 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Can I call Amendment 37 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Can I call Amendment 140 in the name of the Minister, already debated with Amendment 136? Minister, to move formally.
Moved.
The question is that Amendment 140 be agreed to. Are we all agreed? We are not all agreed, therefore there will be a division. Would those members who wish to support Amendment 140 please show? Thank you. Those against? The result of the vote on Amendment 140, there were 8 votes in favour and 1 against. The amendment is therefore agreed to. Can I call Amendment 38 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Not moved. Can I call Amendment 141 in the name of the Minister, already debated with Amendment 136? Minister, to move formally.
Moved.
The question is that Amendment 141 be agreed to. Are we all agreed? We are not. Therefore, there will be a division. Would those members who wish to support Amendment 141 please show? Thank you. Those against? The result of the vote on Amendment 141, 8 votes in favour, 1 vote against. The amendment is therefore agreed to. Can I call Amendment 39 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Not move. Can I call Amendment 142 in the name of the Minister, already debated with Amendment 136? Minister, to move formally?
Moved.
The question is that Amendment 142 be agreed to. Are we all agreed? We are not all agreed. Therefore, would those members who wish to support Amendment 142 please show? Thank you. Those against? The result of the vote on Amendment 142, there were 8 votes in favour, 1 vote against. Therefore, the amendment is agreed to. Can I call Amendment 180 in the name of Liz Smith, already debated with Amendment 136? Liz Smith, to move or not move?
Moved.
Moved. The question is that Amendment 180 be agreed to. Are we all agreed? We're not all agreed. Therefore, there will be a division. Those members who wish to support Amendment 180, please show. Thank you. Those against? Thank you. The result of the vote on Amendment 180, 1 vote in favour, 8 votes against. The amendment is therefore not agreed to. Can I call Amendments 143, 144 and 145, all in the name of the Minister and all previously debated? And can I invite the Minister to move Amendments 143 to 145 en bloc?
Moved en bloc.
Thank you. Can I ask whether any member objects to a single question being put on Amendments 143 to 145? No. Therefore, if no member has objected, therefore the question is that Amendments 143 to 145 are agreed to. Are we all agreed? Did you say? No. Therefore, there will be a division. Would those members who wish to support Amendments 143 to 145 please show? Thank you. Those against? The result of the vote on Amendments 143 to 145, 8 votes in favour, 1 vote against. The amendment is therefore agreed to. Can I call Amendment 181 in the name of Liz Smith, already debated with Amendment 136? Liz Smith, to move or not move?
Not moved.
Not move. Yes, sorry, apologies for that slight delay there. Can I put the question that Section 27 is agreed to? Thank you. Can I call Amendment 146 in the name of the Minister, grouped with Amendments 147 and 182? Minister, to move Amendment 146 and speak to all amendments in the group.
Thank you. I move Amendment 146 in my name. Amendments 146 and 147 provide consistency between the drafting of the guidance powers between Parts 4 and 5 of the Bill, and also achieve consistency with the guidance powers contained in Part 3, which are being amended by Amendments 101 to 103. These amendments also ensure that relevant authorities, as listed in Schedule 2, are to have regard to guidance issued by Scottish Ministers in respect of Part 4, which is consistent with Amendment 148. Amendment 182 would place a duty in the Bill that would explicitly say that guidance can be issued by Ministers in relation to the interaction between the lead professional and the named person. The Bill does not contain express provision about the role of the lead professional because we are looking to public bodies to establish the arrangements that best suit the needs of an individual child. This will not clearly fall to any one agency, and therefore we feel it's more appropriate to address this issue in guidance. Guidance will be developed in collaboration with a wide range of stakeholders and specify how the named person should work with the lead professional and other matters related to that. As mentioned in the committee's Stage 1 report, we will keep under consideration in the future whether proceeding with the lead professional role non-legislatively remains the best course of action. So therefore I ask the committee to support the amendments 146 and 147 and to confirm that I don't support Amendment 182.
Thank you, Minister. Can I call Jane Baxter to speak to Amendment 182 and other amendments in the group?
Thank you. Amendment 182 picks up on a key issue which has been raised in previous consideration of the named person proposal, namely the need for clarification of the role and interface between the named person and the lead professional. There are a number of areas and issues which require clarification. These include, for example, the comparative remits of the named person and the lead person, the respective duties and responsibilities of the named person and the lead person, the demarcation between the decision-making of the named person and the lead person, identification of the areas in which the named person and the lead person will operate and any limits, and whether there are likely to be any overlaps in the roles of the named person and the lead person, and if so, how these will be managed. I appreciate the Minister's comments about her intention to progress this through guidance, because I do think that we need to clarify the relationship between the named person and the lead person. Thank you.
No other members indicated they wish to speak. Minister, wish to wind up?
I thank Jane Baxter for raising the amendments and absolutely recognise that lead professional is a key element of the GIRFEC approach and are committed to taking forward this forward in parallel with implementing the bill's provisions. But for the lead professional, given the greater variety of individuals who take on this role and difficulties in formulating a clear duty in statute, we're not persuaded that legislation is the best place to advance this role. Flexibility is absolutely essential for the performance of this role, and the clarity of who should be performing that role present with respect to the named person should not be embedded in statute. We already, as I've already said in opening remarks, Convener, plan to issue guidance on the named person service, which will contain details on how the named person should interact with the lead professional. We believe that guidance is the best place to balance the consistency of how the lead professional role is taken forward across Scotland with the flexibility in who might take on that role. So for those reasons, amendment, I still believe, Convener, 182 is unnecessary.
Thank you very much. The question is that Amendment 146 be agreed to. Are we all agreed? We are agreed. Can I call Amendment 147 in the name of the Minister? Already debated with Amendment 146. Minister, to move formally.
Moved.
The question is that Amendment 147 be agreed to. Are we all agreed? We are. Can I call Amendment 182 in the name of Jane Baxter? Already debated with Amendment 146. Jane Baxter, to move or not move?
Move.
The question is that Amendment 182 be agreed to. Are we all agreed? We are not all agreed, therefore there will be a division. Those members who wish to support Amendment 182, please show. Thank you. Those opposed? The result of the vote on Amendment 182, 2 votes in favour, 7 votes against. The amendment is therefore not agreed to. Can I call Amendment 239 in the name of Mary Fee? Already debated with Amendment 198 on day 1. Mary Fee, to move or not move?
Move.
The question is that Amendment 239 be agreed to. Are we all agreed? We're not all agreed. Therefore, there will be a division. Those members who wish to support Amendment 239, please show. Thank you. Those against? The result of the vote on Amendment 239, 2 votes in favour, 7 votes against. The amendment is therefore not agreed to. Can I call Amendment 240 in the name of Jane Baxter, already debated with Amendment 216 on day 1. Jane Baxter, to move or not move?
Move.
The question is that Amendment 240 be agreed to. Are we all agreed? We are not. Therefore, with those members who wish to support Amendment 240, please show. Those against? Abstentions? The result of the vote on Amendment 240, 2 votes in favour, 6 votes against, and there was 1 abstention. The amendment is therefore not agreed to. Can I call Amendment 111 in the name of the Minister, already debated with Amendment 95 on day 1? The Minister, to move formally.
Moved.
The question is that Amendment 111 be agreed to. Are we all agreed? We are. The question is that Section 28 be agreed to. Are we all agreed? Can I call Amendment 148 in the name of the Minister, grouped with Amendments 159 to 162? Minister, to move Amendment 148 and speak to other amendments in the group.
Thank you, Convener. I move Amendment 148. These amendments change the list of appropriate bodies which are subject to a duty to assist and share information with the named person. They also ensure that those bodies which are defined in Part 4 as relevant authorities must comply with any directions issued by the Scottish Ministers in relation to the named person functions. The National Waiting Time Centre Board provides a range of specialist services to children and young people and so holds relevant information about children's well-being. The Scottish Court Service, Mental Health Tribunal and Mental Welfare Commission are not primarily public-facing and so are not primary sources of information on children's well-being. They generally obtain their information from other persons already listed in the schedule. They requested to be removed from the schedule, and on review we agree that they should not be on there. A regional strategic body is primarily a funding body and does not, in that capacity, require to be listed on Schedule 2. Where providing education, it would be covered under post-16 education body and so is already listed within the schedule in that capacity. So therefore, Convener, I ask you to support all of the amendments in this group, 148, 159, 161 and 162.
Thank you. No member has indicated they wish to speak. Do you wish to wind up, Minister? Thank you. The question is that Amendment 148 be agreed to. Are we all agreed? We are. Can I call Amendment 241 in the name of Mary Fee, already debated with Amendment 198 on day one. Mary Fee, to move or not move?
Move.
The question is that Amendment 241 be agreed to. Are we all agreed? We're not all agreed, therefore there will be a division. Can those who wish to support Amendment 241 please show? Thank you. Those against? Thank you. The result of the vote on Amendment 241, 2 votes in favour, 7 votes against. The amendment is therefore not agreed to. Can I call Amendment 242 in the name of Jane Baxter, already debated with Amendment 216 on day one. Jane Baxter, to move or not move?
Move.
The question is that Amendment 242 be agreed to. Are we all agreed? We're not all agreed, therefore there will be a division. Can I ask those members who wish to support Amendment 242 to please show? Thank you. Those against? Abstentions? The result of the vote on Amendment 242, there were 2 votes in favour, 6 votes against and 1 abstention. The amendment is therefore not agreed to. Can I call Amendment 112 in the name of the Minister, already debated with Amendment 95 on day one. Minister, to move formally.
Moved.
The question is that Amendment 112 be agreed to. Are we all agreed? We're agreed. The question is that Section 29 be agreed to. Are we all agreed? Can I call Amendment 40 in the name of Liz Smith, already debated with Amendment 6. Liz Smith, to move or not move?
Not moved.
Not moved. Can I call Amendment 149 in the name of the Minister, already debated with Amendment 131? The Minister, to move formally.
Moved.
The question is that Amendment 149 be agreed to. Are we all agreed? Can I just... we're all agreed. Thank you. Can I call Amendment 150 in the name of the Minister, already debated with Amendment 131? Minister, to move formally.
Moved.
The question is that Amendment 150 be agreed to. Are we all agreed? We are agreed. Can I call Amendment 65 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Moved.
It's moved. The question is that Amendment 65 be agreed to. Are we all agreed? We are not all agreed, therefore there will be a division. Can those who wish to support Amendment 65 please show? Thank you. Those against? Thank you. The result of the vote on Amendment 65, there was 1 vote in favour, 8 votes against. The amendment is therefore not agreed to. Can I call Amendment 151 in the name of the Minister, already debated with Amendment 131? Minister, to move formally.
Moved.
The question is that Amendment 151 be agreed to. Are we all agreed? We are. Can I call Amendment 41 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Not moved. Can I call Amendments 152, 153 and 154, all in the name of the Minister and all previously debated? And I can invite the Minister to move Amendments 152 to 154 en bloc.
Moved en bloc.
Thank you. Can I ask whether any member objects to a single question being put on Amendments 152 to 154? No member has objected. Therefore, the question is that Amendments 152 to 154 are agreed to. Are we all agreed? We are. Can I call Amendment 42 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
It's not moved. Can I call Amendment 155 in the name of the Minister, already debated with Amendment 131? Minister, to move formally.
Move formally.
The question is that Amendment 155 be agreed to. Are we all agreed? We are. Can I call Amendment 43 in the name of Liz Smith, already debated with Amendment 6? Liz Smith, to move or not move?
Not moved.
Not moved. Can I call Amendment 156 in the name of the Minister, already debated with Amendment 129? Minister, to move formally.
Moved.
The question is that Amendment 156 be agreed to. Are we all agreed? We are. Can I call Amendment 157 in the name of the Minister? Already debated with Amendment 131. Minister to move formally.
Moved.
Question is that Amendment 157 be agreed to. Are we all agreed? Yes, we are. Can I call Amendment 44 in the name of Liz Smith? Already debated with Amendment 6. Liz Smith to move or not move?
Not moved.
Not move. The question is that Section 30 be agreed to. Are we all agreed? Agreed. Can I call Amendments 158 to 162, all in the name of the Minister and all previously debated, and invite the Minister to move Amendments 158 to 162 en bloc?
Moved en bloc.
Thank you. Can I ask whether any member objects to a single question being put on Amendments 158 to 162? No members objected. Therefore, the question is that Amendments 158 to 162 are agreed to. Are we all agreed? We are all agreed. The question is that Schedule 2 be agreed to. Are we all agreed? Can I call Amendment 243 in the name of Mark MacDonald, already debated with Amendment 216 on day 1. Mark MacDonald to move or not move?
Not moved.
Not move. Given the time and my previous indication to members that I would take a break at some point, I will just break at this point for a short suspension. Thank you. Okay, can I call Amendment 316 in the name of Liam MacArthur, grouped with other amendments as shown in the groupings. Liam MacArthur to move Amendment 316 and speak to all amendments in the group.
Thank you very much, Convener. The amendments in this grouping seek to address what are seen as concerns about the vagueness in the language currently used in the bill, while also more effectively linking up the preventative approach we wish to see through Part 3 on children's services planning with effective delivery of those plans. And once again, I'm indebted to the very broad coalition of expert groups and individuals behind the Keeping the Baby in the Bathwater report for their suggestions on how we might improve the bill in this regard. Amendments 136 and 328 reflect a concern that capable of may be too theoretical, and that what we should be seeking to provide is assurance that wellbeing needs will be met. Amendments 336, 317 and 320 reflect the desire to make the language less vague, setting out more explicitly, particularly in the context of young babies, the needs to be met, while also ensuring that the legislation does not simply sanction a passive or a reactive approach. The evidence from the coalition is that many children with significant needs are amongst those least likely to come to the attention of public services, notably before the age of 3. Amendments 318 and 321 acknowledge that, unlike in many other countries, the great majority of children in Scotland are not meaningfully screened in terms of their overall development in the 2 years following the assessments done in the very first days and weeks of that child's life. This would seem to limit the opportunities for early detection of problems and lead to more costly and perhaps less effective remedial action being taken later on. As well as ensuring that plans capture in a transparent fashion the outcomes in terms of a child's well-being and life chances, it is important that account is taken of any new and emerging needs, again in the spirit of making the preventative approach a reality. That is the thrust of the remaining amendments in this group, which I hope will elicit support, and I look forward to hearing the comments of colleagues and the Minister. And for now, I move Amendment 316 in my name.
Thank you. Can I call Liz Smith?
Just very briefly, Convener, just to say I'm broadly supportive of the amendments in Mr MacArthur's name. I do think regarding this section and one or two that come later, there's been a bit of vagueness surrounding some of the intentions, so I think these are helpful in focusing minds. I'm also grateful to the stakeholders who've given us a lot of information and also helped us to understand from practitioners on the front line just exactly where some of the problems might arise.
Can I call Joan McAlpine?
Thank you very much, Convener. Yeah, I'm also broadly sympathetic to the, very sympathetic to the Baby in the Bathwater campaign, and I moved an amendment at the last meeting of the committee on prevention. I'm not sure that these amendments are all strictly necessary, and I'll be interested to hear what the Minister has to say. In terms of 316, I would be concerned that the child's plan would be required in every case where a child's needs aren't being met, and that might not always be necessary and could divert resources away from where they're really needed. In terms of 317, the bill currently focuses on the desired outcome of well-being, and I'm just not sure that they're all absolutely necessary.
Thank you very much. No other members? Can I call the Minister?
Thank you, Convener, and thank you also to Liam MacArthur for explaining the intent of his amendments, and to echo his thanks to the Baby in the Bathwater Coalition. However, like Joan McAlpine, I don't consider that these amendments are necessary. Amendment 316 seeks to require a relevant authority to develop a child's plan in every case where a child's needs are not being met or not fully met by existing supports. It may have the effect of moving to statutory measures before there has been full consideration of the support which is available in universal services. This amendment would potentially lead to an increase in bureaucracy without any real gain in terms of support to children. The need to consider the full range of universal services potentially available to meet the child's wellbeing needs is necessary to ensure that there is no tendency to move too quickly to specialist services and statutory planning when that is not required. The GIRFEC approach is an outcomes-focused approach which builds on strength to promote resilience in addressing concerns about a child's well-being. Amendment 317 would require any targeted intervention to focus on preventing the child's well-being from being further compromised, rather than focusing on the desired outcomes in terms of improved well-being. This could result in missed opportunities to promote, support and safeguard well-being through early intervention. The bill as drafted requires that any concerns for well-being shared with the named person will be taken into consideration in deciding whether the child requires a child's plan. This would, of course, include any relevant and proportionate information that came to light in the course of routine screening. Amendments 318, 321 and 324 are not therefore necessary. Subordinate legislation created under sections 32 and 37 of the bill will prescribe what information is required within the child's plan, and this will be supported by guidance. Amendments 320 and 326 are therefore also unnecessary. Amendments 322, 323, 330 and 331 aim to achieve similar things in relation to managing the child's plan in Part 5 and reports by corporate parents in Part 7 respectively. We feel they are also unnecessary as they would not add to the assessment of or reporting on the child's well-being, which is already covered fully by Parts 5 and 7. The existing wording of sections 37 covers all wellbeing needs of the child, the appropriateness of any intervention and an assessment as to whether the outcome has been achieved. The amendments are also therefore unnecessary. The level of detail in Amendment 325 is also unnecessary as the intention behind this amendment is already addressed through the Bill's provision in respect of the review of the child's plan in sections 37(1) and 4. Similarly, we feel Amendments 330 and 331 introduce reporting duties that are too specific to apply to all corporate parents. We fully expect corporate parents to take account of wellbeing needs and outcomes when preparing their reports as per section 55(2), which already provides that reports may, in particular, include information about standards of performance and outcomes that have been achieved. The bill already addresses the aim of preventing wellbeing needs from arising, as reinforced by the committee's agreement at the last meeting to accept Joan McAlpine's Amendment 171 in respect of Part 3. With regards to Amendments 336 and 328, while I do absolutely share the desire to ensure that any assessment of needs is robust and comprehensive, I do not consider that the definition of needs being proposed will achieve that. The definition and use of wellbeing within the bill provides a holistic framework, so consequently I do not support the amendments in this group, Convener.
Thank you very much, Minister. Can I call Liam MacArthur to wind up and indicate whether he wishes to press or withdraw?
Thank you, Convener. Can I start by thanking Joan McAlpine and Liz Smith for their comments, but also the Minister for her detailed response and indeed the spirit in which it was offered. Can I also thank again the coalition behind Baby in the Bathwater report, which I think has been incredibly useful and insightful in informing the discussion at stage 2. I think it's provided a useful opportunity to highlight some of the important issues raised. I don't suppose the amendments will be passed, but I hope that they will go some way to informing the way in which guidance is subsequently developed in due course. And with that, I move Amendment 316 in my name.
The question is that Amendment 316 be agreed to. Are we all agreed? We are not all agreed, therefore there will be a division. The question is that, could those members who wish to indicate their support for Amendment 316 please show now. Thank you. Those against? The result of the vote on Amendment 316, there were 4 votes in favour and 5 votes against. Therefore, the amendment is not agreed to. Can I call Amendment 257 in the name of the Minister, grouped with other amendments as shown in the groupings? Minister to move Amendment 257 and speak to all amendments in the group. Minister.
Thank you. I move Amendment 257 in my name. While the bill rightly places duties on public bodies to provide the right help to children to promote, support and safeguard wellbeing, the Scottish Government also recognises the important role which the third sector can play in local communities to support children and their families. These amendments broaden the definition of targeted intervention to cover provision of services by a third party, for example, a third sector provider not contracted by the Health Board or local authority. Under these amendments, a relevant authority can arrange for a third sector organisation to provide such interventions. So this is absolutely not about privatising key services, as the responsibility for the child's plan remains with a responsible managing authority. If we value the contribution of the third sector in supporting wellbeing, then we need to ensure that there is a mechanism to coordinate that support within the statutory planning framework where appropriate. These amendments ensure the full range of interventions in support of the child is captured in the child's plan, and that all interventions provided are in accordance with the child's plan and the child's needs. Those providing a targeted intervention would be a partner to the plan. The bill also requires anyone providing a targeted intervention in terms of the plan to be consulted when the plan is being reviewed. This will not place a duty on third sector organisations to provide a targeted intervention, but recognises the absolutely important role of third sector services within their communities. The voluntary sector have asked for these amendments and will welcome them, I believe, as they ensure that the valuable work that they do will continue to be included in the Child's Plan. Therefore, Convener, I ask the committee to support the amendments in my name in this group.
Thank you very much. No member has indicated they wish to contribute at this stage. Minister, any need to wind up?
I'll waive that.
Thank you. The question is that Amendment 257 be agreed to. Are we all agreed? We are. Can I call amendments 258, 259 and 260, all in the name of the Minister and all previously debated? And can I invite the Minister to move amendments 258 to 260 on block?
Moved on block.
Thank you. Can I ask whether any member objects to a single question being put on amendments 258 to 260? No member has objected. Therefore, the question is that amendments 258 to 260 are agreed to. Are we all agreed? We are. Can I call Amendment 336 in the name of Liam MacArthur, already debated with Amendment 316? Liam MacArthur to move or not move? Moved. The question is that Amendment 336 be agreed to. Are we all agreed? We're not all agreed. Therefore, there will be a division. Can those members who wish to support Amendment 336 please show? Thank you. Those against? Thank you. The results of the vote on Amendment 336, 4 votes for, 5 votes against. The amendment is therefore not agreed to. Can I call Amendment 317 in the name of Liam MacArthur, already debated with Amendment 316? Liam MacArthur to move or not move? Move. The question is that Amendment 317 be agreed to. Are we all agreed? We are not all agreed. Therefore, could those members who wish to support Amendment 317 please show? Thank you. Those against? Thank you. The result of the vote on Amendment 317, there were 4 votes in favour, 5 votes against. The amendment is therefore not agreed to. Can I call Amendment 261 in the name of the Minister, already debated with Amendment 257? Minister to move formally.
Moved.
The question is that Amendment 261 be agreed to. Are we all agreed? We are. Can I call Amendment 262 in the name of the Minister, grouped with other amendments as shown in the groupings? I have to point out that if Amendment 183 is agreed to, I cannot call Amendment 263 in this group and Amendment 244, already debated on day 1, because of preemption. Minister to move Amendment 262 and speak to all amendments in the group.
Thank you, Convener. I move Amendment 262 in my name. Amendments 262, 272, 280 and 297 ensure a consistent link between the named person and the creation, management and review of a child's plan where the named person does not work for the authority responsible for the plan. The amendments ensure that the named person is at the heart of the single planning process and that the plan is prepared using accurate, relevant information about the child's well-being. Where the named person is an employee of the responsible authority, they would lead on the preparation and review of the child's plan as appropriate. However, it will not always be appropriate for the named person to prepare the plan. For example, when a concern emerges about a child who requires urgent intervention by a specialist or targeted service provider, such as child protection, when it might be right for social work to lead on that plan. These amendments will ensure that named persons will always be contacted to gain a full picture of the child's well-being to decisions about the plan. Amendments 263, 273, 274 and 281 widen the scope of whose views should be regarded when preparing and managing a child's plan. They enable ministers to specify who should be consulted and to direct or permit that a copy of the plan be given to a person or persons. This will allow the views of all relevant persons in the child's life to be sought and considered throughout the child's plan process. Amendment 283 makes a minor drafting amendment to section 37 in light of Amendment 282, which has already been debated with Group 25. So for those reasons, I ask you support the amendments in my name. Amendment 183 by Liam MacArthur adds an additional requirement for responsible authorities to consider the child's age and maturity when obtaining their views on the need to have a child's plan. Secondly, it requires responsible authorities to provide the child with an opportunity to indicate whether they wish to express a view when deciding if a child's plan is required. I agree with the principle of what Liam is trying to do, but believe the bill already achieves this. I'm clear that responsible authorities should always seek to obtain the views of the child, no matter their situation, their age, their maturity, their disability, communication or other needs. We acknowledge that in exceptional circumstances this may not be reasonably practicable, for example in the case of very young babies. The requirement to obtain the views only so far as reasonably practicable clearly also allows for the child to decline to give a view if they wish to. The current provisions allow for this already. The first part of this amendment could provide a situation where responsible authorities could take a predetermined view that children are either too young or immature to provide a view without testing that assumption with the child. Our preferred position is for authorities to always seek the views of the child whenever reasonably practicable and to take account of the child's age and maturity when having regard to any view expressed. With regards to the second part of his amendment, I believe the bill as drafted provides sufficiently for children to choose whether or not to provide a view. So therefore I believe Amendment 183 is unnecessary and maybe suggest that it could be withdrawn.
Thank you, Minister. Can I call Liam MacArthur to speak to Amendment 183 and other amendments in the group? Liam.
Thank you, Convener. As I made clear when moving my amendments last time to Part 1 of the bill, I firmly believe that if this legislation is not to be seen as a missed opportunity, then it must do more to ensure that the child's voice is heard as part of the process of deciding how best to meet that child's needs and serve their interests. As I said last time, both the Faculty of Advocates and the Law Society, amongst others, have questioned the extent to which the bill advances in any way the rights of the child, and this, I think, is highly regrettable. My Amendment 183 attempts to try to redress this deficiency, making clear the right of the child to be heard and have his or her views taken into account in the development of any plan. This may seem self-evident, but I don't think it can be taken for granted, and in light of the comments from the faculty, the Law Society and others, there is clearly more work to be done if this legislation is to live up to its billing. I think it's also worth ensuring that steps are taken to seek the views and have regard to the views of the child's parents as part of this process, and this is reflected in the final part of Amendment 183. On that basis, I hope colleagues will see fit to support the amendment. In terms of the Minister's amendments, these seem broadly helpful, but I think would benefit from the addition of my Amendment 183, which I will be moving in due course. Thank you.
Thank you very much. No member has indicated they wish to contribute at this stage, so Minister, do you wish to wind up?
Thank you. Convener, as I said in my opening remarks, authorities should always seek to obtain the views of the child, and I agree with some of the principle in which Liam MacArthur has made his remarks. But if Liam MacArthur's amendment were agreed, then responsible authorities could take a view that children are either too young or immature to provide a view without testing that assumption with the child. And that risk is very real. Now, I do not believe that anyone with an interest in the bill would wish that to happen. I absolutely don't believe that. I think, as we've already said, we do have a degree of consensus around much of what we're trying to achieve within this bill, and I sincerely believe that nobody wants that to happen. Also, again, to reiterate, the bill as drafted provides sufficiently for children to choose whether or not to provide a view. So I ask the committee to support my amendments in this group and to not support the amendment in Liam MacArthur's name.
Thank you. The question is that Amendment 262 be agreed to. Are we all agreed? We are. Can I call Amendment 183 in the name of Liam MacArthur, already debated with Amendment 262? And can I remind members that if Amendment 183 is agreed to, I cannot call Amendments 263 and 244 because of preemption. Liam MacArthur, to move or not move? The question is that Amendment 183 be agreed to. Are we all agreed? We're not all agreed, therefore there will be a division. Those members who are supporting Amendment 183, please show. Thank you. Those against? Thank you. The result of the vote on Amendment 183, 4 votes in favour, 5 votes against. The amendment is therefore not agreed to. Can I call Amendment 263 in the name of the Minister, already debated with Amendment 262? Minister, to move formally.
Moved.
The question is that Amendment 263 be agreed to. Are we all agreed? We are. Can I call Amendment 244 in the name of Jane Baxter, already debated with Amendment 216 on day one? Jane Baxter, to move or not move?
Move.
The question is that Amendment 244 be agreed to. Are we all agreed? We're not all agreed. Therefore, can those members who wish to support Amendment 244 please show? Thank you. Those against? Thank you. The result of the vote on Amendment 244, there were 2 votes in favour and 7 votes against. That amendment is therefore not agreed to. Can I call Amendment 318 in the name of Liam MacArthur, already debated with Amendment 316. Liam MacArthur, to move or not move?
Move.
The question is that Amendment 318 be agreed to. Are we all agreed? We're not all agreed. Therefore, would those members who wish to support Amendment 318 please show? Thank you. Those against? The result of the vote on Amendment 318, there were 4 votes in favour and 5 votes against. The amendment is therefore not agreed to. Can I call Amendment 45 in the name of Liz Smith, grouped with Amendments 46, 47, 300 and 312? Liz Smith to move Amendment 45 and speak to all other amendments in the group.
Thank you, Convener. And can I move Amendment 45? Amendments 45, 46 and 47 follow from very extensive evidence that was presented by several different groups of stakeholders throughout this process. And they would introduce provisions for the resolution of disputes regarding the need, the content and the management of a child's plan. Quite conceivably, there could be instances where parents feel that a plan is either unnecessary or inappropriately administered. But as the bill stands, the avenues through which such a grievance could be addressed are very unclear. Amendment 45 would correct this by introducing a dispute resolution process to be assessed by parents who disagree with the decision to initiate a plan. Amendment 46 relates to the preparation of a plan. Currently, Section 33 states that where the responsible authority and relevant authority agree to be more appropriate for the latter to prepare a child's plan, the relevant authority is to proceed as soon as is practical. But what happens if both authorities do not agree to this? As it stands, only a reason for disagreement has to be stated, which is not actually helpful when it comes to actually trying to address the specific difficulties. Just because there is a disagreement doesn't mean that there is going to be satisfactory discussion about the specific problems. A dispute resolution process would, on the other hand, speed up the drafting of a plan, overcoming any difficulties which might arise between responsible and relevant authorities, and Amendment 46 would also further strengthen the hands of parents who disagree with the content of a child's plan. The final amendment for me on this is number 47, relating to the management of a plan, once again making provision for a process which will resolve potential disputes as they emerge. I think the same themes occur in the amendments 300 and 312 in the name of Liam MacArthur, which we'll come to later, which seek to introduce independent advocacy services. And so I think that probably covers similar ground, but I think these are very worthwhile in terms of trying to clarify matters, and I look forward to hearing the Minister's response.
Thank you. Can I call Liam MacArthur to speak to Amendment 300 and other amendments in the group?
Thank you. Convener, earlier spoke of the need to make sure that the child and indeed the child's parents or guardians have their voice heard during the development of a child's plan. In many instances, this will be fairly straightforward to achieve, but I think we're all aware from cases in our constituencies and in our regions where the involvement of advocacy support is absolutely critical to enabling some people, often very vulnerable individuals, to make their voice and their views heard effectively. My amendments 300 and 312 recognise that need, particularly where there may be disagreement and emotions are already running high. They make modest but nonetheless important provision for advice on what advocacy support is available and assistance in ensuring that that is indeed accessed. They do not create, I believe, any new rights to advocacy, but are consistent with existing legislation and leave open considerable scope for ministers to determine how this may be delivered. Without such provision in this bill, however, we risk effectively excluding many of those who might benefit most from the changes being made through both Parts 5 and indeed Parts 3 of this bill. These, I think, as Liz Smith indicated, fit very well with Liz Smith's own amendments on dispute resolution, which seem to me both sensible and beneficial.
No other member has indicated they wish to contribute. I'll make a brief comment, if I may, before bringing in the Minister. I think there is a question about dispute resolution that has to be resolved here. So I'm not convinced necessarily that these amendments are the answer, but at the same time, I think there has been evidence that suggests that there is a question mark over the current status of the bill in this area, and I'd be very interested to hear what the Minister has to say with regard to her assessment of where the bill stands and what possible remedies that she may wish to bring forward. And with that, can I call the Minister?
Thank you, Convener. The Scottish Government is committed, absolutely committed to clear, quick and accessible routes for redress for children and parents regarding the GIRFEC duties proposed within the bill. We are also committed to ensuring that a redress mechanism is in place in advance of the commencement of the GIRFEC duties currently scheduled for 2016 as set out in the financial memorandum. We don't, though, want to add unnecessary complexity to the complaints landscape where there are existing mechanisms with regard to how people can challenge decisions or roles in public services. The Scottish Public Services Ombudsman, the independent body which handles complaints about devolved public services in Scotland, highlighted in evidence to the committee the difficulties sometimes caused by the complexity of complaints processes. Now, I agree with Liz Smith and our stakeholders that there has to be a clear route of redress for parents, families and children in relation to the proposed GIRFEC duties in Part 5 and have sympathy for the motivations behind Amendments 44, 45 and 46. However, 45, 46 and 47 do not properly capture all of the issues that need to be considered. For instance, other issues we need to consider include how children and young people, not just their parents, are able to challenge decisions taken about them if they feel their needs are not being met. And if appropriate, this is not covered in Amendments 45, 46 and 47. We also wish to ensure that disputes concerning different duties relating to the GIRFEC planning process, for example, the need for a plan and the content of the plan, are properly linked so that we avoid overly complicated and time-consuming processes. We need to ensure, therefore, that there are the right avenues in place for taking forward a challenge, but should not do this in isolation from the outcomes of other wider considerations of dispute resolution in social work, or the existing complaints processes already in place in local authorities, health boards and other public bodies. That's why we are open to considering the possibility of an order-making power, but not the one that's proposed here. We would then be happy to further discuss the issues around dispute resolution processes with Liz Smith and yourself, Convener, and others, including whether an enabling amendment might be required for Stage 3, or alternatively, what can be taken forward more appropriately and effectively without the need for legislation through this bill. So on that basis, I can't support the amendments 45, 46 and 47. And while I also sympathise with the motivation behind amendments 300 and 312, I'm not able to support an independent advocacy service as outlined to be provided by the bill. The Government is committed to developing guidance to support all of those involved in the provision of advocacy support to children and young people. That guidance will build on a set of principles and standards for independent advocacy which were published by Scottish ministers in December last year. While best practice should always be to inform children and families where they might seek support in the event of a dispute about a child's plan, a statutory obligation to signpost a child and his or her parents to independent advocacy in all cases where there is a dispute relating to a child's plan is not proportionate. Further, the definition of independent advocacy services in terms of the Mental Health Care and Treatment Scotland Act 2003, which is focused on persons with mental disorder, is not necessarily appropriate for child's plans, which will cover a number of children with a wide range of differing needs. So while I have real sympathy with much of what Liam MacArthur has said, I don't support the amendments in that group.
Thank you very much. Can I call Liz Smith to wind up and to indicate whether she wishes to press or withdraw?
Thank you, Convener, and thank you, Minister, for what are very helpful comments. And if I can hold you to the commitment that you've just made ahead of Stage 3, because I do think this is an issue you raised in your own speech, that there's often complexity and a lack of understanding. I think part of that has been created by the problem that parents actually don't know what to do. They don't know where the process lies. So I think there is a very real need to ensure that we tackle this before Stage 3. So on the basis that I hold you to that commitment, I will not move 45.
No, you have moved it. Do you wish to withdraw?
Withdraw, sorry.
Are members content to allow that to be withdrawn?
Yeah.
Okay, thank you. The question is that Section 31 be agreed to. Are we all agreed? Can I call Amendment 264 in the name of the Minister, already debated with Amendment 257? Minister to move formally.
Moved.
The question is that Amendment 264 be agreed to. Are we all agreed? We are. Can I call Amendment 265 in the name of the Minister, already debated with Amendment 257? Minister to move formally.
Moved.
The question is that Amendment 265 be agreed to. Are we all agreed? We are. Can I call Amendment 319 in the name of Liam MacArthur, grouped with Amendments 266 to 271? Liam MacArthur to move Amendment 319 and speak to all amendments in the group.
Convener, thank you. Amendment 319, which I have pleasure in moving, is very much in keeping with the thrust of what I've sought to achieve in previous groupings of amendments, namely the involvement of parents as well as the child in the development of a child's plan. I believe the importance of this needs to be more explicitly stated within the bill, as does the fact that we don't just wish to see parental involvement, but recognise that at times this may require to be supported in order to be effective. In terms of the Minister's amendments in this grouping, I will be interested to hear her comments, but I see no difficulty with them at all. Thank you. And I move Amendment 319.
Thank you. Can I call the Minister to speak to Amendment 266 and other amendments in the group? Minister.
Thank you. My amendments in this group seek to ensure that a child's plan can only contain a targeted intervention where the authority which is to provide it agrees to do so. They also ensure that where there are no targeted interventions which can be included in a child's plan, the duty to prepare a plan is removed. Amendment 266 helps to ensure that only those professionally qualified to determine the appropriateness of a targeted intervention can agree to have it included in a child's plan. For example, where the relevant authority is a health board, they must agree to the health service report where requested to provide it by a local authority. Where such a service is being asked to provide a targeted intervention and they believe in their professional opinion that is unnecessary or inappropriate, then they can disagree with its provisions. Such situations will not be commonplace, and when a service disagrees, they will have to provide a statement of reasons for doing so, which will provide some level of accountability. Amendment 271 ensures that where there are no targeted interventions which could be contained in a child's plan because a relevant authority does not agree to provide an intervention, then the duty on the responsible authority to prepare the plan is removed. This will prevent child's plans being put in place when disagreements exist over what interventions can be provided, and will ensure that unnecessary interventions that are not in the child's best interest are avoided. Guidance will ensure that services are clear as to when such a situation may arise and the appropriate manner to deal with them. Amendments 268, 269 and 270 are minor amendments which are being made in consequence of Amendments 266 and 271. The amendments do not affect the general duty on a responsible authority to prepare a child's plan if a child has a wellbeing need, so that if there are other targeted interventions which could be provided to meet the wellbeing need, there will still be a requirement to prepare a plan. Amendment 267 is a typographical amendment which removes a stray A in section 32. Amendment 319 proposes that all plans stipulate support arrangements for the child's parents and how parents will be included in the plan. This is not necessary or appropriate in all cases. The child's plan must focus on the needs of the child. If support is required to help the parent in order to improve the wellbeing needs of the child, then that will be recorded in the plan. But to make the inclusion of this information a requirement in all cases is not proportionate or necessary. So in summary, I do not support Amendment 319, but support the other amendments in this group in my name.
Okay, thank you. No members have indicated they wish to speak at this stage, so Liam MacArthur to wind up and to indicate whether they wish to press or withdraw.
Only to say, Convener, that I think it's confirmation that the Minister's amendments in this grouping are indeed helpful in improving the bill, but I'm not convinced that there isn't a need for 319 as well, so I will press the amendment.
The question is that Amendment 319 be agreed to. Are we all agreed? We are not all agreed, therefore there will be a division. Can I ask those members who wish to support Amendment 319 to please indicate? Thank you. Those against? Thank you. The result of the vote on Amendment 319, 4 votes in favour, 5 against. The amendment is therefore not agreed to. Can I call Amendment 320 in the name of Liam MacArthur, already debated with Amendment 316. Liam MacArthur to move or not move? The question is that Amendment 320 be agreed to. Are we all agreed? We're not all agreed, therefore there will be a division. Can I ask those who wish to support Amendment 320 to please show? Thank you. Those against? The result of the vote on Amendment 320, 4 votes in favour, 5 votes against. The amendment is therefore not agreed to. Can I call Amendment 266 in the name of the Minister, already debated with Amendment 319? Minister to move formally.
Moved.
The question is that Amendment 266 be agreed to. Are we all agreed? We are agreed. Can I call Amendment 267 in the name of the Minister, already debated with Amendment 319? Minister to move formally.
Moved.
The question is that Amendment 267 be agreed to. Are we all agreed? Agreed. The question is that Section 32 be agreed to. Are we all agreed? Can I call Amendments 268 to 273, all in the name of the Minister and all previously debated, and invite the Minister to move Amendments 268 to 273 en bloc?
Moved en bloc.
Can I ask whether any member objects to a single question being put on Amendments 268 to 273? No members objected. Therefore, the question is that amendments 268 to 273 are agreed to. Are we all agreed? We are agreed. Can I call Amendment 321 in the name of Liam MacArthur, already debated with Amendment 316? Liam MacArthur to move or not move?
Not moved.
Not moved. Can I call Amendment 46 in the name of Liz Smith, already debated with Amendment 45? Liz Smith to move or not move?
Not moved.
It's not moved. Call Amendment 274 in the name of the Minister, already debated with Amendment 262. Minister to move formally.
Moved.
Question is that Amendment 274 be agreed to. Are we all agreed? We are agreed. The question is that Section 33 be agreed to. Are we all agreed? Call Amendment 275 in the name of the Minister, grouped with Amendment 276. Minister to move Amendment 275 and speak to both amendments in the group. Minister.
Thank you. I move Amendment 275 in my name, and Amendment 275 corrects another typographical error in the bill. Amendment 276 is necessary to clarify that a local authority placing any child into an independent or grant-aided school outside the local authority area retains the responsible authority status in respect of that child. This means that they will be responsible for determining whether a child's plan is required. Where appropriate, they will also prepare and manage the plan. Amendment 276 likewise ensures that when a child is placed or detained in residential accommodation, including secure accommodation in an area other than their home local authority area, the home local authority area retains responsibility for the child's plan. This reflects current good practice where a child's home local authority retains responsibility for looked after children when they are accommodated outside of their local authority area. This amendment seeks to ensure that the provisions of Section 35 reflect that current good practice, which is why I support this amendment. And in summary, I ask the committee to support both of the amendments in this group.
No other member has indicated I wish to contribute. Minister, do you wish to wind up? Thank you. The question is that Amendment 275 be agreed to. Are we all agreed? We are. The question is that Section 34 be agreed to. Are we all agreed? Can I call Amendment 276 in the name of the Minister, already debated with Amendment 275? Minister to move formally.
Moved.
The question is that Amendment 276 be agreed to. Are we all agreed? We're agreed. The question is that Section 35 be agreed to. Are we all agreed? Can I call Amendment 277 in the name of the Minister, already debated with Amendment 257? Minister to move formally.
Moved.
The question is that Amendment 277 be agreed to. Are we all agreed? We are. The question is that Section 36 be agreed to. Are we all agreed? Can I call Amendment 322 in the name of Liam MacArthur, already debated with Amendment 316? Liam MacArthur to move or not move? Not moved. Thank you. Can I call Amendment 278 in the name of the Minister, already debated with Amendment 257? Minister to move formally.
Moved.
The question is that Amendment 278 be agreed to. Are we all agreed? We are. Can I call Amendment 245 in the name of Jane Baxter, already debated with Amendment 216 on day one? Jane Baxter to move or not move?
Not move.
Not moved. Can I call Amendment 323 in the name of Liam MacArthur, already debated with Amendment 316? Liam MacArthur to move or not move? Moved. Not moved. Can I call Amendments 279, 280 and 281, all in the name of the Minister and all previously debated? And I invite the Minister to move Amendments 279 to 281 en bloc.
Moved en bloc.
Can I ask whether any member objects to a single question being put on Amendments 279 to 281? No members objected. Therefore, the question is that Amendments 279 to 281 are agreed to. Are we all agreed? We are agreed. Can I call Amendment 324 in the name of Liam MacArthur, already debated with Amendment 316? Liam MacArthur to move or not move? Not move. Can I call Amendment 282 in the name of the Minister, already debated with Amendment 257? Minister to move formally.
Moved.
The question is that Amendment 282 be agreed to. Are we all agreed? We are. Can I call Amendment 283 in the name of the Minister, already debated with Amendment 262? Minister to move formally.
Moved.
The question is that Amendment 283 be agreed to. Are we all agreed? We are. Can I call Amendment 246 in the name of Jane Baxter, already debated with Amendment 216 on day one? Jane Baxter to move or not move?
Not move.
Not moved. Can I call Amendment 284 in the name of the Minister, already debated with Amendment 257? Minister to move formally. The question is that Amendment 284 be agreed to. Are we all agreed? We are. Can I call Amendment 325 in the name of Liam MacArthur, already debated with Amendment 316? Liam MacArthur to move or not move? Not move. Can I call Amendment 285 in the name of the Minister, already debated with Amendment 257? Minister to move formally.
Moved.
The question is that Amendment 285 be agreed to. Are we all agreed? We are. Can I call Amendment 326 in the name of Liam MacArthur, already debated with Amendment 316? Liam MacArthur to move or not move? Not move. Can I call Amendment 47 in the name of Liz Smith, already debated with Amendment 45? Liz Smith to move or not move?
Not moved.
Not moved. The question is that Section 37 be agreed to. Are we all agreed? Can I call Amendment 286 in the name of the Minister, grouped with other amendments as shown in the groupings? Minister to move Amendment 286 and speak to all other amendments in the group. Minister.
Thank you. I move Amendment 286 in my name. Amendments 286, 287, 288, 289, 290, 291 and 292 extend the duty to provide assistance, advice and information under Section 38 to persons listed in the new schedule, which is inserted by Amendment 293. This allows authorities who are exercising Child's Plan's functions to ask those persons in the schedule for information and assistance with regards to the Child's Plan in the same way that a named person can prior to the plan being initiated. This strengthens the bill in relation to children with high-level needs, where coordinated input from a range of services may be necessary to promote, support and safeguard their well-being. Amendments 292 and 311 add a power for the new schedule to be modified by order of the Scottish Ministers and provide that such an order would be subject to the affirmative parliamentary procedures. Amendments 294, 295 and 296 amend the provisions around guidance and directions in Part 5 of the bill to achieve consistency across the bill as a whole and take account of the fact that Scottish Ministers will be listed in the new schedule in relation to Part 5 of the bill. So I'm finished.
Finished, Minister.
I'm finished.
Thank you very much. Sorry. No other member has indicated they wish to contribute at this stage. Do you wish to wind up, Minister?
Oh, I'll waive that.
Thank you. Question is that Amendment 286 be agreed to. Are we all agreed? We are. Can I call Amendments 287 to 291, 163, 164 and 292, all in the name of the Minister and all previously debated? Can I invite the Minister to move Amendments 287 to 291, 163, 164 and 292 on block?
Moved on block.
Thank you. Can I ask whether any member objects to a single question being put on Amendments 287 to 291, 163, 164 and 292? No member has objected. Therefore, the question is that Amendments 287 to 291, 163, 164 and 292 are agreed to. Are we all agreed? The question is that Section 38 be agreed to. Are we all agreed? Can I call Amendment 293 in the name of the Minister, already debated with Amendment 286? Minister to move formally.
Moved.
The question is that Amendment 293 be agreed to. Are we all agreed? We are agreed. Can I call Amendment 300 in the name of Liam MacArthur, already debated with Amendment 45? Liam MacArthur to move or not move? The question is that Amendment 300 be agreed to. Are we all agreed? We're not all agreed, and therefore there will be a division. Can those members who wish to support Amendment 300 please show? Thank you. Those opposed? The result of the vote on Amendment 300, 4 votes in favour, 5 votes against. Therefore, the amendment is not agreed to. Can I call Amendment 294 in the name of the Minister, already debated with Amendment 286? Minister to move formally.
Moved.
The question is that Amendment 294 be agreed to. Are we all agreed? We are. Can I call Amendment 247 in the name of Mary Fee, already debated with Amendment 198 on day 1? Mary Fee to move or not move?
Move.
The question is that Amendment 247 be agreed to. Are we all agreed? We are not all agreed. Therefore, there will be a division. The question is, would those members who wish to support Amendment 247 please show? Thank you. Those opposed? Thank you. The result of the vote on Amendment 247, 2 votes in favour, 7 votes against. The amendment is therefore not agreed to. Can I call Amendment 248 in the name of Jane Baxter, already debated with Amendment 216 on day one? Jane Baxter, to move or not move?
Not move.
Not moved. Can I call Amendment 113 in the name of the Minister, already debated with Amendment 95 on day one? Minister, to move formally?
Moved.
Question is that Amendment 113 be agreed to. Are we all agreed? We are. Question is that Section 39 be agreed to. Are we all agreed? Can I call Amendment 295 in the name of the Minister, already debated with Amendment 286? Minister, to move formally.
Moved.
Question is that Amendment 295 be agreed to. Are we all agreed? We are. Can I call Amendment 296 in the name of the Minister, already debated with Amendment 286? Minister, to move formally.
Moved.
The question is that Amendment 296 be agreed to. Are we all agreed? Can I call Amendment 249 in the name of Mary Fee, already debated with Amendment 198 on day one? Mary Fee, to move or not move?
Move.
That's moved. The question is that Amendment 249 be agreed to. Are we all agreed? We're not all agreed. Therefore, would those members who wish to support Amendment 249 please show? Thank you. Those against? Thank you. Result of the vote on Amendment 249. There were 2 votes in favour, 7 votes against. The amendment is therefore not agreed to. Can I call Amendment 250 in the name of Mark MacDonald, already debated with Amendment 216 on day one? Mark MacDonald, to move or not move?
Not moved.
That's not moved. Thank you. Can I call Amendment 114 in the name of the Minister, already debated with Amendment 95 on day one? Minister, to move formally.
Moved.
The question is that Amendment 114 be agreed to. Are we all agreed? We are agreed. The question is that Section 40 be agreed to. Are we all agreed? Can I call Amendments 297, 298 and 299, all in the name of the Minister and all previously debated? And can I invite the Minister to move Amendments 297 to 299 en bloc?
Moved en bloc.
Thank you. Can I ask whether any member objects to a single question being put on Amendments 297 to 299? No member has objected. Therefore, the question is that Amendments 297 to 299 are agreed to. Are we all agreed? We are agreed. The question is that Section 41 be agreed to. Are we all agreed? Can I call Amendment 251 in the name of Mark MacDonald, already debated with Amendment 216 on day one? Mark MacDonald, to move or not move?
Not moved.
Not moved. We're at the end of part 5. I'm going to call a very short suspension for just 2 minutes, if you don't mind, and we'll come back after that. Thank you. Thank you. Given where we are on the bill, I've decided that we'll stop here and pick it up again next week. We didn't get through as many of the amendments as we'd hoped to, but we'll start again next week at part 6 in the bill, and we'll pick up parts 8 to 11, hopefully. We'll get as far through that as we possibly can next week. The deadline for lodging amendments to parts 8 to 11 of the bill is this Thursday at noon. Can I thank the Minister and our officials for attending today, and can I suspend briefly to allow Minister and officials to leave the table. Our second item today is to consider correspondence received from the European and External Relations Committee relating to our EU priorities. As you can see from the papers, a draft response is included for consideration today. As the response outlines, we have not yet decided upon the detail of our approach to the various items in our work programme, and so the relevant EU issues are indicative only at this stage. As the committee's work programme takes shape, our EU reporter will highlight relevant EU issues from consideration as appropriate. And of course, I'm sure our EU reporter will also take part in the debate that the EU committee will have on its priorities, which I believe is scheduled for February. Do members have any questions or any points they want to make on the paper? Okay. Are members therefore agreed to the response, the draft response, to the European and External Relations Committee? Is that agreed? Okay, we'll get that sent off. And can I thank members very much for their participation today, and we'll close the meeting.